Hey, everybody. So this tape is about where tort law comes from. And in the course of it, I'm going to explain a little bit about outlining and elements and those sorts of things. I know that you get some of that during orientation and in other classes, and that's fine. It doesn't hurt to hear it more than once. All right. So where does the law come from that we're going to be studying in our class? All right. Let me pull up something here. All right. Okay. So there's two main places, right? One is the common law. Now, you've probably heard the term common law, and you may be saying, gosh, I'm not quite sure what people mean. And that's very fair because it means different things in different contexts, and it means different things to different people. So to some people, it means the law at some place in time, like the common law of England in 1850 or something. But that's not how I'm using it here, and we usually use it in first year classes. It's a process by which the law is made. And the process is that it's made by case, right? Rather than a legislature making the law. So, and it's painstaking. It takes decades and centuries to make a law. So, somebody will say, this guy banged into my shoulder when he was going past me. And the court will say, wow, yes, the touching of another is a battery, and you should be compensated. Now, they didn't look at all the issues of battery, right? Because that wasn't presented in the case. That's why common law decision making takes so long. It's case by case. So then the next case comes along, and some guy hits him in the shoulder, but he's kind of just trying to get by in a line or something. And the court says, well, that isn't a battery. Well, there's a touching, right? And that's what the first case maybe held, maybe didn't. So now we have to refine the rule a little bit, that it's a intentional touching with that causes bodily harm, right? And then the next case, maybe it doesn't cause bodily harm, but it causes mental distress. And so then we say, okay, so it's an intentional touching, for example, well, let me make it concrete. We're going to have an example where some guy is holding a plate in line, and a waiter comes and whacks the plate, and there's some racial epithets exchanged. But he never is touched. The only thing that's touched is the plate. And the court said that was a battery. Well, we got to then, redo the definition, right? And so it's a touching with bodily harm, or something that you're holding or adjacent to you, and if it's not bodily harm, it could also be if it's offensive or something. So case law just kind of builds on each other over time, and it takes a long time, and it's difficult to try and understand all of tort law by looking at it case by case by case. All right, so more of that in a minute. But most of our case law, some from England, some from the United States, has been developed through the common law decision-making method, meaning that it's case by case. We extract what we think the rule is in that case, and we apply it to the next case, and the court says, yes, you were right, and this is a battery, or no, we have to refine the definition a little bit, and it goes on and on and on. All right. The second way is by statute. We're going to look at some statutes in torts. For example, we're going to look at the stand your ground law in Florida, and that's a statute that gives a defense sometimes to a battery claim. But most of our tort law is done by the common law method. Now, you can imagine, right, that somebody someday said, man, this figuring out tort law is hard. It'd be nice if there was a book where some bright law professor or something gathered all the rules together. And in fact, there is such a book. Now, it's a little complicated, but stick with me for 4 or 5 minutes, and hopefully I can explain it. So back in the 20s, the first book where somebody said, let's gather all the common law rules that pertain to a subject was contract. And then shortly thereafter, it was torts. And it's done by a group called the American Law Institute. It's got judges, lawyers, practitioners, that sort of thing. And there's a subcommittee, and then there's a head poobah of the subcommittee who kind of does most of the work. And what the poobah does is pretty much reads every tort case or every tort case on a particular issue, and then throughout the United States, and then tries to extract a way of describing the majority rule. You can't do all the rules because sometimes Iowa just has it different than North Carolina. But if you look at the 50 states, there's usually a consensus as to what the rules are, and that's what the restatement did. The restatement of torts took the majority rules of the 50 states at least for the torts that it wrote about, and said, here is what generally an assault is, a battery is, a negligence is, those sorts of things. So that was helpful. But then again, it happened first in contracts, but then happened in torts. People said, well, laws change, and maybe the first restatement guys didn't get it right. So we have the second restatement of torts. And that became kind of that was written by one of the, he's posthumous, but one of the authors of our casebook, Prosser. And he was the head poobah. And Prosser was a giant in tort law, and everybody agreed Prosser had done a really good job. So it took a long time before anybody said, do you think we need a third restatement? Because it was about 40 years between the first and the second, and it's been about 55, 60 years between the second and the one we got now. Or the one that's being done now. You'll say, yeah, maybe we do. But before I kind of talk to you about the restatement third of torts, because it's got a different approach, I want to show you what the restatement second of torts looks like and why there's no statutory supplement or something that you can buy. This is the restatement second of torts. Now, not all of it are the rules. Some of it are comments and illustrations, some of it are appendices, but it's big, but that goes to show the thoroughness of Prosser and putting everything together. So here's what happened. It takes a long time to draft something like this big, so what they decided to do for the restatement third of torts is they would look at individual areas of torts. So there are many restatement thirds of torts. And the one that we'll be looking at first is called the restatement third of torts for intentional torts to the person, because we're going to look at intentional torts first. And they've made some progress in that. And they're pretty much done with the restatement third of torts and intentional torts to persons. So that's the one we'll use. There, as we go throughout the course, some of which we'll use the restatement second because the restatement third hasn't been written yet, or it's still being drafted and discussed, or it hasn't proven very fruitful. But where there's a restatement third of torts, by and large, unless you hear me say something different, that'll be our rule. Okay, now, what do these rules look like? All right, so this is something you may have heard already, but again, as I said, it didn't hurt to hear it a couple of times. Every claim, every defense, every crime in the United States is broken down into something called elements. For crimes, it's constitutional. You have to know what it is you can't do in order to be convicted of a crime. So residential burglary is something like an intentional breaking and entering the dwelling of another without permission with the intent to commit a felony. And so that's what the prosecution has to prove. Every defense, where the defense has the burden of proof, has elements too. So if you can prove this defense, then you didn't commit the crime, or you're not liable for in the civil case. And so what the restatement did was try to break all the torts down into their elements. Now, again, it's not the law anywhere. It's a compilation of the law everywhere. It's the majority rule throughout the United States. So it might be exactly the same in California as it is in the restatement of torts, but it might be different a little bit. Maybe it's not different in substance, it's just said differently, but the restators had to pick a way of saying it. And so far, I think they have been very trustworthy in what they say does appear to be the modern law of torts to the extent that they address the issue. So let me show you kind of what it looks like. Now, I'm going to be posting most of these because, one of the things you need to, I think students want to know, and I want to be able to share with you is, what are the elements? What is false imprisonment? What does it take to get an assault or a battery or something? And those are the elements. And again, for our part, most of the time they come from the restatement. So that means, our cases are kind of hypotheticals applying the restatement as the rule. So we, and we can look and say, see, this case put it a little differently, and that's one of those things that state by state they're a little different. But when it comes time for exams or something, that the language is going to be from the restatement. Now, let me tell you two things that hopefully will, be good news for you. First off, although the restatement all has numbers and everything, I'm never going to require you to say, oh, this is a restatement of third, section 102 or something. I don't care that you memorize section numbers. In practice, you can look them up. Secondly, is I never require the exact wording of the restatement. As long as you make an accurate paraphrase, that's fine. Sometimes they made an effort in the restatement of thirds to kind of tone down the language and make it simple, but still, you don't have to repeat it verbatim. This isn't a memory contest. Third, is same thing about cases. I'm never going to ask you to recite a particular case back to me. If we're going to look at 400 or 500 cases throughout the course of the year, and so it would be impossible anyway, even if you had a great memory. So we'll talk more about exams as we get there, but I just want to ease your mind now, and then that you're never going to have to memorize section numbers. You're never going to have to memorize case names or exact language. All right, but let me show you what something looks like from the restatement third of torts. And this is, I'll give you the relevant sections of this. I'll post them on Brightspace for all the torts that we're going to recover. Excuse me, that we're going to cover. Let me, here we go. All right, there you go. So I printed this right from one of the general databases that has the restatement third of torts. If you want in class, we can go through how to find them on Westlaw and Lexis and everything, but it's fairly straightforward. I think this one came from Westlaw, but Lexis has exactly the same too. All right. So when somebody asks you what's a battery, you can tell them. Well, here's a battery, and subject to liability for battery if the one guy, the defendant, right, intends to cause a contact with the person of another, or let me just not do let me read it in a little bit different way than it's presented, and I'll come back and fill in the other. So the actor intends to cause a contact with the person of another. The actor's affirmative conduct causes such a contact. So you intend to cause a contact and you actually cause a contact. The contact either causes bodily harm to the plaintiff or is offensive to the plaintiff. And the plaintiff does not consent to the otherwise tortious conduct of the actor. In the first tape I had you look at, I talked to you about a football game. Well, these three things are true of the football of one lineman who hits another, but the linemen consent to be hit by each other, at least to some great extent. So, all right. So, what's a battery? That's a battery. Right now, you see that we say that the actor intends to cause a contact with the person of another. All right, so that means intent must have a definition too, and it's not in there. Well, we have to intent, we'll have to look to section 102. Or the actor's intent is sufficient under section 110, which is something called transferred intent. So intent is a little more complicated than just the normative use of the word. And then you'll see down here, it causes bodily harm to the other. Now they don't have a section, but that has a definition too, or is offensive is provided in section 103. So we're gonna have to get our definition of offensive from there. And then the other doesn't consent. Oh, consent's covered apparently in section 111. And so you see how they kind of that the restatement third is trying to give you the cross references to tell you, look, there are places you can go to find these definitions. The restatement second didn't do any of that, but this is, I think, helpful. All right, now we'll go over battery in the first couple of classes, including intent. And then you're going to sit there and you're going to want to, if you've heard about these things about outlines, right? You want to outline for the exam. Now, if it were up to me, right, and if you take my advice, I would not start outlining until we're finished with all the intentional torts. If you do it right away, the first weekend, we won't be finished with kind of intent and assault and battery, which kind of go together. You can put something down on paper, but then you may have to revise it later and all that. So if you take my counsel, you'll wait for about 3-4 weeks till you get through with the intentional torts, and then you'll do the outlining because you'll have a better idea. But I know some of you are anxious, want to get started right away. You're going to have some time in the first weekend because everybody starts in the second weekend because we all start a little bit slow. So you get to know us, get to know how law school goes and stuff. So I understand if you say, yeah, for us, Brain, I may have to erase it or revise it, but I want to at least get to it and see what it's like. All right. So this is kind of what an outline looks like. Now, which I'm going to show you in a second, but beforehand, but wait, right? The couple things about an outline. All right. First of all, it's for you. I'm not going to grade your outline. You could have the best outline and the worst exam. So the outline doesn't have to be pretty or flowery. It's got to be you. It's a tool for you. And it's a tool for you to organize the course in a way that that makes sense, so that when something happens that might be a battery, that you say, what am I supposed to remember about a battery? And you can think back to your outline. And one of the reasons that we all encourage you to do your own outlines, not even to be in a study group where you share outlines, and not to just rely on a commercial outline. Commercial outlines have all the elements. They're they're accurate. I've never seen one that I thought was wrong, even if I might put it a little differently here and there. But it's passive, right? If you got to sit down and you got to write down or type, what a battery is and organize it in a way that makes sense to you, it's going to be more, you're going to remember it. And so that's why you really should do your own outline. But outlines kind of come from the elements of a fit, because when you see something that might be a battery, you want to remember the elements, right? So it would look something like this, all right? This is how you'd start your outline. There'd be a section on intentional torts, and then number one would be battery, since we're doing that first, all right? And remember how actor intends to cause a contact with the defense. So intent to cause a contact with another. You could put defendant. Like I said, I don't care about the exact wording as long as it's accurate paraphrase. Now, remember, we've got intent in 102, we've got intent in 110. They probably mean different things. They have, there's something you want to remember. So you'd have a 1 under here that would be what intent is under the 102. You'd have a 2 under here for what the intent was for transferred intent under 110, and you'd write something, right? Now, what you write is got to be what's important to you. You may remember some things. I'll never forget it, right? So you don't have to write it down again, or you can abbreviate it or something. Remember, this is a tool for you, so that when you think back on an exam, you get a battery thing. Let me make sure I'm thinking of everything. I'm thinking of intent to cause a contact with another. Oh yeah, intent can be 2 ways. It can be the 102 way or the 110 way. And so you'll write something that will reflect what we talk about in class, but will also be meaningful to you. So student A's outline on what they write is going to be different than student B's outline, just because prompt words and the abbreviations and stuff are going to be different. All right, so then you're going to have a B, right? Because that's this part. The affirmative conduct actually causes a contact. So you've got such conduct that actually causes a contact. And then you've got, I will tell you, there'll be something in here about causation and what that means. And then you'll have the contact that causes bodily harm or is offensive, right? Okay, that comes from the common law we talked about. So it's the contact either has to cause bodily harm, and you'll have some definition of what bodily harm is, or is offensive, and you might put a note to yourself. The plate case, right? That's an example of how we have an offensive contact. Again, I don't care about the name of the case. Maybe on an exam you'll remember it as, oh, this was like the plate case, and then that communicates something to me. But even if you didn't write the plate case and you just told me what an offensive contact was, and then analyze whether the contact in the hypothetical I gave you on the exam was offensive or not, that would be fine. And then here is no consent. And then you go on to assault, right? So the second tort that we cover. So how long outline should be depends on how quickly you type, how much you think you have to get it down, whether you abbreviate or not. It's impossible to tell. Remember, it's a tool for you. Sometimes people even make 2 outlines where they will make a long outline and then a shorter outline with the stuff that they really important stuff, or the stuff that they might forget. I know most of that stuff in the big outline, but this is stuff I forget, so I'll make a second outline. I mean, that's a lot of outlining instead of doing practice exams, which I think are the best way to study for exams. But we'll talk more about that as we get closer to the midterm. But that's what you do. When people talk about outlining, that's what they do. Now, do you have to outline? Absolutely not. You got to do what's best for you. It's a tool. Like I said, I'm never going to see it. people bring me their outline, I'm not going to look at them. Not because I'm a mean person, but outline has to be useful for you, and I don't know what's useful for you. Now, if you have a question about the law, should this be in my outline? Did I phrase this right? Happy to talk to you about that. But in terms of looking at your outline and saying, oh yeah, you have everything here, or you don't, there's some things you missed. I can't do that because I don't know what's in your head. So that's why I can't tell you how long your outline should be. But in terms of whether you should have an outline at all, a student I taught when I at Pepperdine, when I taught Torts, never made an outline. Finished #1 in his class, and in fact, he's now the president of Pepperdine University. And he, I think he made a mental outline. I've talked with him, and he doesn't. He said that it just didn't seem to make sense to him to spend the time to write stuff. He just kind of thought about it. And as I said, I think he made this in sort of his mental outline and something like that. But he thought about what battery was, what the issues might be, and satisfied himself that he knew what to look for when there was a battery on an exam. So, but by writing them down and typing them and all of that and organizing them, this anytime you'll have a battery, you'll think, okay, I got to have intent. There's got to be a contact. Contact's got to be one of these two things, and there can't be consent. And you can look for those, in the fact scenario. So again, I would wait, but I understand if you get anxious. And want to start, but that's at least kind of how it works. So as I said, how you study for exams and all that, I'll talk about a little bit more as we get closer to the midterm. But you'll have in your 5-unit class, you'll have you'll have you'll have gone through that once in the middle of the semester. But it is having something you can touch, having something that you've created, having something that you've thought about. I think is helpful as a way to approach an exam. One last thing, some people do flashcards, make their own flashcards. So they'll put battery. And then on the other side of the flashcards, they'll have something like this, and then they'll have intent as a flashcard, and turn it around, and they've got the two kinds of intent and something to say about them. That works for some people, doesn't work for some. Didn't work for me, but some people swear by flashcard. So again, this is the idea of preparing for exams is find what works for you. And you might not find it. That's why we have midterms that don't count as much as the finals. Is the way you decide you're going to attack the midterms, you may change for the finals, but at least the traditional majority view of how to do it is prepare an outline, maybe these other flashcards in addition, and then take practice exams. So. Any questions about it? As always on these tapes, shoot me an email, see me before class. Happy to talk to you about it. But hopefully this was of some help in explaining what the restatements were, how we get our tort law, and what to expect when we go through the cases.